All right, welcome to Talk Testimonies. We're diving deep into a Supreme Court case today.
Yeah, think of it as your shortcut to understanding complex legal arguments. No need to sift through pages and pages of transcripts.
Exactly. We're going to break down a significant case, Lamps plus Inc. v. Varela, and give you the insights you need. We're your guides to the highest court.
That's right. Today, we're zeroing in on the oral arguments presented to the justices, laying out the core of the dispute, and then exploring the key questions and discussions that took place.
By the end of this, you'll have a solid grasp of the issues, just as if you'd been sitting in the courtroom.
Absolutely.
So let's dive in.
Yeah.
At the center of Lamps plus v. Varela is this really fundamental question. If you have an arbitration agreement and it doesn't explicitly mention class actions, can it still be interpreted to allow them?
Yeah, and the arguments really revolved around how state contract law and federal arbitration law work together.
Right. So first, let's take a look at the arguments from the petitioners, Lamps plus. They basically argued that the Federal Arbitration Act, the FAA, and previous Supreme Court decisions, especially the Stolt-Nielsen case, established this clear and unmistakable evidence standard.
That's right. They're saying you need clear evidence that both parties agreed to class arbitration for it to be allowed.
So for them, silence on class actions doesn't automatically mean consent, even though their agreement said something like, all claims or controversies are subject to arbitration.
Right. They argued that class actions are kind of a different animal, and you can't just assume they're included without explicit agreement.
Like saying all fruit doesn't necessarily mean you're also talking about like durian fruit.
I like that analogy. And to strengthen their point, they even drew a parallel to another area of arbitration law where the clear and unmistakable standard already applies.
Oh, interesting.
Yeah. So the Supreme Court has said that if you want an arbitrator to decide certain preliminary issues, like whether the arbitration agreement itself is valid, that needs to be spelled out very clearly.
I see.
And Lamps Plus argued that the power to conduct a class arbitration is just as significant. Therefore, it should require the same level of explicit consent.
So they're basically saying agreeing to class arbitration is a huge deal, not something you can just infer from general language.
Precisely. And they also raised a really important point about fairness and due process.
Right. The idea that someone who isn't directly part of the arbitration could be bound by the outcome of a class action without ever actually agreeing to be part of it.
Exactly. That was a key part of their argument. Now let's shift gears and look at the arguments made by Varela. Their lawyer basically said we should rely on standard neutral principles of state contract law to figure out what this particular arbitration agreement really means.
And they emphasized the specific language Lamps Plus used in their agreement. It was something like, all lawsuits or civil legal proceedings relating to my employment are subject to arbitration.
Right. And Varela argued that based on California law, where the contract was made, that broad language could definitely be read to include class arbitration.
Especially since Lamps Plus was the one who wrote the contract.
Exactly.
If you're the one writing it, you should be crystal clear about what you mean.
Absolutely. And on a broader level, Varela's argument fits with the general principle that the FAA instructs courts to enforce arbitration agreements according to the parties' intentions.
Yeah. And how do you figure out those intentions?
Well, by using the same rules of contract interpretation we use for any other agreement.
Right. So it's like a contract is a contract and we should treat it as such.
Right.
Varela's side also made a really practical observation. They pointed out that if Lamps Plus was serious about avoiding class actions, they could easily include a specific waiver in the agreement, like many companies do now.
Right. The fact that they didn't explicitly exclude class actions could be seen as telling.
Exactly. They also argued that the specific procedures of an arbitration, including the decision of whether a class should be certified, are typically left up to the arbitrator, not for the courts to decide at the outset.
That's like saying, the referee gets to decide on some of the specific rules of the game within certain boundaries.
Makes sense.
Yeah.
So we've got these two contrasting viewpoints, but what were the Supreme Court justices themselves really interested in?
That's where things get really interesting. What the justices ask during oral argument can tell us a lot about what they're thinking. So, for instance, Justice Sotomayor really pressed on whether Lamps Plus even had the right to appeal the lower court's decision to send the case to arbitration. Yeah, she was exploring the difference between a case being dismissed versus being put on hold and how that affects the right to appeal.
Okay.
She also questioned whether the issue of class arbitration should have been decided by the arbitrator right from the start.
So she was sort of asking, Are we even looking at the right question here?
Exactly. Now, Justice Kagan, she really pushed Lamps Plus on why that broad contract language wouldn't naturally include class claims. It seemed like she thought it'd be kind of strange to create a special federal rule just for interpreting arbitration agreements that's different from how we interpret most other contracts.
Right.
She made this great analogy. If a sign says, all drinks are half price, you wouldn't think it excludes, like, large sodas unless it specifically said so. So why wouldn't all disputes include all types of disputes, including class action?
That's a good point. It really highlights the core of the disagreement. Then there was Justice Breyer, who also had some thought-provoking questions, right?
He did. He wondered why the court should treat these mid-case appeals, what they call interlocutory appeals, any differently for arbitration agreements.
Yeah, and he didn't seem very convinced by the argument that sending a case to class arbitration automatically means it'll settle.
Right. And he specifically questioned California's rule about interpreting ambiguous contracts against the drafter, which in this case was Lamps Plus.
So he seemed to be pushing back against the idea that arbitration agreements deserve special treatment, both procedurally and when it comes to interpreting them. What about Justice Ginsburg? What was her focus?
Justice Ginsburg highlighted something we mentioned earlier, this trend of companies increasingly putting specific class action waivers in their arbitration agreements. She basically asked, look, if companies want to avoid class arbitration, and they're already doing that by just saying so, why do we even need a special federal rule?
Right. It's like if there's a simple fix, why overcomplicate things? Then there was Justice Alito, who had some pretty big concerns, right?
Absolutely. He zeroed in on the due process implications of binding people to an arbitration they didn't directly agree to. And he was concerned about what would happen if state law was used to interpret contracts in favor of arbitration, even when there's no specific clause about class actions. He really seemed worried about fairness to those absent class members.
Okay, makes sense. And what about Justice Gorsuch, the textualist? What was his line of questioning?
Well, he questioned the role of lower courts in dictating the nitty-gritty procedures of an arbitration, especially something as major as a class action proceeding.
Okay.
He seemed worried that allowing this could lead to more legal battles over procedural stuff, which kind of defeats the purpose of arbitration being a faster alternative to going to court.
Right.
And he also asked if an arbitrator would be obligated to follow a court's initial decision about whether class arbitration is even allowed.
So he was concerned about maintaining the efficiency and autonomy of the arbitration process itself.
Precisely.
And lastly, what about Justice Kavanaugh?
Justice Kavanaugh spent a lot of time on the precedent set by Stolt-Nielsen. He seemed particularly interested in figuring out exactly how clear an arbitration agreement has to be to allow for class arbitration. Basically, he was trying to understand what the bar is for that clear and unmistakable evidence standard that Lamps Plus argued for.
So, as we can see, a real mix of viewpoints from the justices, showing just how complex it is to balance federal arbitration law with state contract law and individual rights.
Absolutely. Now let's put on our imaginary robes and step into that 10th chair on the Supreme Court. If I were a justice considering all these arguments, I'd probably lean towards this perspective. The FAA aims to encourage arbitration, no doubt, but it does so based on the agreement of the parties. And there's a pretty fundamental difference between a one-on-one arbitration and a class action that could affect loads of people who weren't even involved in drafting the agreement.
The difference in scale is pretty huge.
Exactly. Now, state contract law gives us the general rules for understanding agreements, but the unique nature and far-reaching impact of class arbitration makes me think that agreeing to this kind of collective dispute resolution shouldn't be easily assumed from broad general language.
Right.
So while I wouldn't necessarily require the specific words class arbitration to be there, I'd argue that the clear and unmistakable standard should demand more than just vague clauses to really prove that both sides knowingly agreed to handle their disputes as a class action.
Okay.
This approach respects the basic principle of consent in contract law while also acknowledging that class arbitration is a whole different ballgame.
It's like finding that balance between making arbitration easier and ensuring things are fair.
Exactly.
So that concludes our in-depth look at the oral arguments in Lamps Plus, Inc. v. Varela. We've gone over the key points made by both sides explored those thought-provoking questions from the justices, and even tried to offer our own perspective from that 10th chair.
Yeah, this case really highlights the tension between the federal push for arbitration and the principles of state contract law, all while trying to ensure due process, especially when it comes to class actions. And it shows how seemingly simple contract language can have really complex legal consequences.
We hope this deep dive has given you a clear and concise understanding of this really important legal debate. What aspects of this case stood out to you? What other questions do you have about arbitration or how the Supreme Court operates? This is just the start of your journey into the legal world.
And on that note, here's something to think about. Regardless of how the Supreme Court ultimately decides in Lamps Plus, how do you think this case might change how companies write their arbitration agreements in the future?
Interesting.
Will we see a jump in more specific language about class action waivers? And what effect could that have on the ability of individuals to team up and address their grievances? Definitely something to ponder.
Lots to think about for sure. Thanks for joining us.
Until next time.